Good afternoon, everyone. Welcome to this online seminar on intersectional discrimination. My name is Rehan Abeyratne. I am an assistant professor at CUHK Law and the executive director of our new Center on Comparative and Transnational Law, or CCTL. This is actually CCTL's first event, and I'm delighted that we were able to get such an excellent group of speakers and that so many of you are joining us today. Let me begin by introducing the speakers, and then we'll get right to it. So our lead speaker and author is Shreya Atrey, Associate Professor in International Human Rights Law at the Faculty of Law and Department for Continuing Education, based at the Bonnevero Human Rights Institute at the University of Oxford. Her research is on discrimination law, feminist theory, poverty and disability law. Her monograph, Intersectional Discrimination, was published last year by Oxford University Press and is, of course, the subject of our seminar today. The book presents an account of intersectionality theory in comparative discrimination law. We also have two commentators for today's seminar. So first, we have Mara Malagodi, who is an assistant professor here at CUHK Law. Dr. Malagodi is a comparative constitutional lawyer and socio-legal scholar with a linguistically informed specialism in South Asian law and politics, human rights law, gender and law, legal history, and law and film. She is also a non-practicing barrister in England and Wales and an award-winning documentary filmmaker. And then last but not least, we have Professor Kelley Loper, who is an associate professor at the University of Hong Kong Faculty of Law, and was until recently the director of the HKU Center for Comparative and Public Law. Professor Loper is the co-director of the LLM in Human Rights Program and co-editor-in-chief of the Asia-Pacific Journal on Human Rights and the Law. Fittingly for the seminar, she also teaches an elective course on equality and non-discrimination. So welcome to you all. Thank you all so much for doing this. And let me hand over to Professor Atrey.
Hi, Rehan. Thanks so much. Thank you all for being here. I can see we have about 71 participants, which is not exactly what we hope when we are in one room together. In the UK, there are fire and safety regulations for almost all small places. We're about 20. So the pandemic has really been quite a catalyst for bringing us together in ways, but also isolating in other ways. I recognize it's not just a global health crisis, but a humanitarian and human rights crisis. So the more we can continue to talk about our work and inequalities and inequities and just try to think of it and make the connections and draw from them into our own context and make them translate into our own context, the better it is. So I suppose one way to approach this talk for the 70 or so of us is to really see this as a template for what we want to do with how the world is organized in terms of inequalities and discrimination. How do we want to approach it, and how do we want to dismantle those inequalities and discrimination? I will share my PowerPoint with you all, if that's all right. You should be able to see me as well. Yeah. So I have a short PowerPoint which should help if I disappear, if my connection drops or something. So I'll leave you with a nice image. But otherwise, I'll be using it to just keep us on tap for the next 25 minutes or so that I have. I'm just going to turn my clock on so I know where we're going. So I'm primarily concentrate on telling you a bit more about intersectionality than telling you more about discrimination law, which is for the purposes of the book a comparative context. So we're particularly thinking of the US, UK, South Africa, Canada, India, the European Union laws, and the European Court of Human Rights jurisprudence, none of which includes Hong Kong. So I think it might be better to think primarily in terms of what intersectionality entails and have an idea of the basic structure of discrimination law, which replicates all around the world. And Kelley may be able to speak to how replicable that structure may be in Hong Kong. But we'll use the basic structure of how do we prohibit discrimination on particular grounds and what the standard of review is as a basic template. But we'll keep in mind exactly what intersectionality is and what we can do about it as the central problem here. And then I want to leave you with answering the question what intersectionality is not about. And I think so much of the debate around intersectionality in the past 30 years, when the term has been around, has really been about the myths surrounding intersectionality. The critiques of intersectionality have really ruled the roost in this context. So it's important to sort of address those critiques and say, where do they actually stand and what do they say about how we approach intersectionality in discrimination law. So why I wrote this book. So I want to say something about why I wrote the title Intersectional Discrimination beyond what you may see in the book. Now, so intersectionality is an interesting field. When you approach it, as I did as an Indian lawyer, I was approaching it from my own context, thinking about the context of women of caste. So I was thinking about the lowest caste or women outside of the caste system. We use the reclamative term Dalit to refer to those who are of low caste or outside of the caste system. And I was thinking of what happens to the quality of discrimination that you face when you're a Dalit woman. And that's when I started thinking about 15 odd years ago. And when I came to look at intersectionality, when I arrived at Oxford, I was thinking of intersectionality still in that context. But then I started making connections that almost everywhere people seem to be intersectionally disadvantaged. This is obvious. So everybody has an identity in terms of race, gender, ethnicity, nationality, citizenship, age, disability, and if we span across all of those identities, it is possible that you are disadvantaged in more than just one of these. So it is also possible that not everybody is just a woman or just a black person or just a Dalit person. That there will be women who are Dalit women who are disabled or black women who are lesbians. How do we make sense of everyone's disadvantage in that context? Now, this has been a question, a research question for black women for the last 200 years. So when you approach this area, you're looking into, or you're looking back to 200 years of rich theoretical and practical discourse. That's what intersectionality is. And to approach this area, you really have to trace that genealogy. And you're not tracing the genealogy with a sense of genuflecting to it, that this is something that we must regard something then that this is where its roots lie, so we must know its roots well. But what you come to realize is that if it is that old a discipline, how is it that intersectionality has become this buzzword, is so old and it's so prolific? So from Beyonce to Hillary Clinton, people use intersectionality as with the sense that, oh, we know it, we're very well versed with it. But how is it that we still don't seem to get intersectionality right in law? It's one of those words which has become a buzzword even within legal academia, and we seem to invoke it rather than have it do much work. So the term itself, intersectionality, was coined by Kimberly Crenshaw in the context of discrimination law when she wrote in 1988 her path-breaking article in the University of Chicago Law Forum, which was called Demarginalizing the Intersection of Race and Sex. But it's been 30 years since she wrote that amazing piece. We haven't quite got to grips with how exactly do we translate that concept into discrimination law. So we're confronted with this great legacy, but we also see that we don't quite get somewhere. We're banging our heads against the wall. I wanted to crack this conundrum, this problem of why can't we just get it right in law, especially discrimination law, which, mind you, to remind you, it is the syntactic side of its origin, the syntax, intersectionality, the term comes from discrimination law. Kimberly Crenshaw was writing in discrimination law. But if we haven't gotten anywhere, then it's a question to ask and to try to solve, which is why I thought it'd be useful to think about what is it about the structure of discrimination law which stops us from getting past this wall of intersectionality. So what is this book about? You see the table of contents. It's an unusually small table of contents, but that was the only way to sort of organize this project. To say that there are really just four things to this project. One is to think about where is intersectionality in discrimination laws around the world. So the first part of the book is defining this project in terms of tracing the legislative and judicial trajectories of development of equality law or discrimination law, whichever that you choose. I think there's great debate whether you want to call something equality law or discrimination law. We're going to skip that, but I hope you're with me when I say equality law or discrimination law. It's basically law relating to inequality. So if you're being discriminated against on the basis of your race, color, religion, sexual orientation, gender, sex, then you're basically talking about equality or discrimination law. But if that's the law we're talking about, where is the law in the UK, US, South Africa, Canada, India, EU, ECHR, in all of those jurisdictions with respect to intersectionality? So the first part of the project, which is chapter 1, is really coming to the conclusion that a quick whirlwind survey that you do of intersectionality or intersectionality in discrimination law, you realize quite quickly that laws don't quite get through the door, right? So most of the laws that you see around the world don't recognize discrimination on the basis of more than one ground, what is basically intersectional discrimination. To say that discrimination is normally prohibited on the basis of one ground at a time. So if you're discriminated on the basis of race, you're protected, but not if you discriminate against on the basis of your race and your gender, or on the basis of your race, gender, and disability. Keep adding grounds. It seems that the more vulnerable or disadvantaged that you are, the less protected that you are in discrimination law. So the first part of the book, the first chapter, really sets this context out, which is an oxymoron. How are we in discrimination law at a point that we protect people less if they're more disadvantaged? But that's the state of the law. The second chapter of the book, which is what I'll be concentrating on in the rest of the talk as well, is really to think about, well, if we have to get intersectionality right in discrimination law, we have to begin with intersectionality. So the second chapter is thinking about what intersectionality is. And here's where some of the more ambitious work is happening in the book. Can we really define intersectionality in the way that I've tried to do in the book? I think the answer is that no, we cannot. But I think for the purposes of discrimination law, we need to have some kind of a working definition of the different moving parts of intersectionality. If we believe that intersectionality is that complex, following its 200-year-old trajectory, then we must have something to say for the different elements which make up intersectionality. And it's on those elements that I wish to concentrate in the rest of the talk. But let me say before then, the last two things that the book does. So chapter 3 does this thing of mapping along a spectrum or a continuum of the categories of discrimination and say, where does intersectionality sit? If you imagine a spectrum of possibilities, single access discrimination, which Kimberly Crenshaw, when she was writing her article in 1988, was critiquing. So discrimination being banned on a single ground is single access discrimination. That's the model of discrimination law follows. It's single access. You're protected only if you have one identity at a time, one disadvantaged identity. Intersectionality, where you're discriminated against when you have multiple identities and they combine in unique ways to yield the discrimination that you suffer. So if you're a gay Muslim man, all of those identities combine to affect you in the way that you are affected by discrimination. That was 1988. In the last 30 years of operation of discrimination law, a lot much more has happened. Categories of discrimination have proliferated. So think about in your own jurisdiction. Is it just single and intersectional discrimination, or are they one of these different kinds of discrimination in the middle, right? We're thinking about when we say substantially single access discrimination, that we recognize that of course women can be poor or women can come from ethnic backgrounds, but we really think that it's sex or gender at play. That's substantially single access discrimination. Let's take this route more often than not, because they're clever people. They kind of get that it can be more complicated, but they don't know how to address that complexity. But it could also be a matter of what we say nowadays, contextual discrimination. Every discrimination is a matter of context. So we just try to see that the neighborhood that you live in, the language that you speak, the specific socioeconomic status that you come from, all of them make an impact on the specific context of discrimination that you face. And we say that multiple identities are by and large a matter of context. So if you look at context harder, even if you're focusing on a single axis, you can understand discrimination. That's contextual discrimination. But you can also approach this complexity in a way where you say, oh, there are just multiple grounds. Race can have an impact, sex can have an impact, disability can have an impact, but they have an impact in a concrete, precise, coherent way that we can separate out the different elements and establish them on their own. This conceptual clarity, which seems to be behind multiple discrimination, or the idea that discrimination can be based on multiple grounds taken in turn rather than simultaneously, is not borne out in practice. We don't live multiple lives. We experience discrimination as one, as the person that you are. So it's hard to say whether discrimination can be sort of put into silos. But this is a very common technique used around the world by justices who, as you can imagine, for most of us who are lawyers here, we can imagine the tendency to really put things in silos, to really bracket it out and say, oh, it's about this or it's about that. It's also the tendency with theory and with philosophers who approach equality and discrimination, or to say, this is really about one kind of discrimination, and it forms a nice, neat model of discrimination, but it doesn't quite comport with the reality of how people who are multiply disadvantaged face discrimination, not as silos, but as one. So these are the different options the third chapter highlights and says, look, if we have to do this right, let's actually think about discrimination in a more concrete way and try to move from along these categories to the end point of intersectional discrimination. So the third chapter really tries to capture the essence of intersectional discrimination as against these other. The last chapter is the really meaty one. It comes to the technical framework of discrimination law and takes people through the entire labyrinth of discrimination. How is it organized? So when we say discrimination, what do we mean? Do we mean disadvantage? Do we mean stigma, prejudice? Do we mean somebody is deprived of their autonomy, liberty, or is it some idea of an egalitarian equality law? What are we saying when we say discrimination? Then we move to questions like, what is direct and indirect discrimination? What is reasonable accommodation? What do we think of when we think about the standard of proof, the burden of proof, or the standard of review that we apply when we assess intersectional claims? What should be the evidentiary burden on claimants? What kind of remedies should we be awarded? All of these questions are questions which are technical to the discipline of discrimination law. The book goes through each of them and tells the reader exactly what we can do about each of these elements which make up the framework of discrimination law to recalibrate it to address intersectionality. So the central argument of the book, if you see the 4 chapters as a whole, is really that there is no magic bullet to address intersectional discrimination. And that's the key learning for discrimination lawyers, that it's not enough to verse yourself with the vocabulary of intersectional discrimination, or to know whether we should be using these grounds on other grounds, or whether we should be using, for those of you who are familiar, the comparator test, or whether it's a matter of direct discrimination or it's all indirect discrimination. I think all of these discrete questions, whichever you're interested by, it's good to remember that they can't really be approached as independent, self-standing questions. You have to treat the body of discrimination law as a whole and take intersectionality beyond its conceptual understanding to something practical and workable, to be addressed within the discourse of discrimination law. So there's no magic bullet. We take it as a whole. But for the purposes of this and for the next step of intersectionality, which I think is more universal and translates very well. And I think it's important to do that if as good discrimination lawyers, we want to know what it's really about. So I want to say something about the second chapter of the book, which answers the question, what is intersectionality about? And there's this multicolored definition that I've put up there. It's so mouthy. I'll just try to read it out, and you'll all probably realize it's one of those definitions which is trying to really overwhelm you. I promise you there's purpose to it, and I'll try to break these elements down. But let's see how mouthy this is. So I think this is the definition that I propose. Intersectionality illuminates the dynamic of sameness and difference, and that's the first phrase that we'll deconstruct. So it's intersectionality illuminates the dynamic of sameness and difference in patterns of group disadvantage based on multiple identities understood as a whole and in their full and relevant context, with the purpose of redressing and transforming them. I think the purpose of this very mouthy definition is really to say, if you're going to look at 200 years of history, there's a possibility that too many things emerge. It's useful to sort of bring them in a cohesive definition to say a lot of this will have to come into the definition of intersectionality. It's not one thing, it's a complex thing. But also to say, for the purposes of intersectionality, the 5 elements that I've highlighted here are really the most significant. So I think the most significant thing which appears in the 200-year-old scholarly history of intersectionality is this idea of dynamic of sameness and difference. So for those of you who are familiar with feminist theory, know that feminists grapple with this idea of, are women just the same as men, or do we want to really emphasize our differences? So is everything different? Are we not the universal paradigm of what we call being humans? Intersectionality sort of cuts through that and says, look, people who are disadvantaged on more than one ground, say as Black women who are both Black and women, have similar experiences of discrimination to, say, white women and Black men. This emphasis of sameness and difference at the same time, the simultaneity of discrimination happening to you because you're a woman, because you're Black, or because you're poor as well. All of this happening in the same time has something similar to other groups. This is often imagined in the sense of a Venn diagram. So if you see sex or gender and race as 2 spheres intersecting, then the sphere, the point of the 2 spheres intersecting, that portion is where Black women reside. So they have something which is similar to Black men because they also face discrimination on the basis of race. It's not like Black women are suddenly transported into a category of their own. They have nothing to do with Black men, nothing to do with women as such. They belong to those categories. They, of course, face discrimination which is similar to sex discrimination and race discrimination, simpliciter. But it's also different at the same time, because that unique portion at the middle of the Venn diagram also is having characteristics of their own. That's the first thing. The second thing is we're thinking about patterns of group disadvantage. So we're not really thinking about isolated instances. We're thinking about patterns, say in the context of Black women, which have resided since slavery. Right? So we're thinking about how Black women have been used as sites of reproductive labor to be producing more slaves 200 years ago, when intersectionality was at its starting point. But also since then, intersectionality bears out in the history of the United States since slavery has been prohibited in the way that Black women have been discriminated against and oppressed and dominated in the specific forms of discrimination that they face today, which are different from slavery. But that discrimination, we're looking at these motifs of patterns of discrimination, right? These are abiding, so they stay on. These are extremely weighty in nature. They're not just small instances of somebody saying something, oh, I don't like you because of your race. It's not just some kind of verbal, like, oh, I don't prefer people of some race. This is disadvantage at the socioeconomic level where people face extreme disadvantages in education or employment. So we're looking at these big, massive patterns of discrimination. But we're also looking at them, and that's the third thing, we're looking at them as a whole. We're not trying to say that this is all a matter of race or all a matter of poverty or all a matter of sex or gender or just a matter of disability. We're trying to say that the only way you'll comprehend intersectionality properly is to look at it as a whole. This is a point which comes from disability law, to really see people as one, as who they are, rather than in law's language try to sort of bring them into digestible packets of, oh, she's a woman or she's a black woman. It's to say that women can't just be compartmentalized into their many identities, but to really see what it means to be a whole person and to experience discrimination that way. The fourth thing which the definition presses on is what's the relevant context that you're talking about. So for those of you who've read Chimamanda Adichie's fantastic book, Americana, she says that when she was in Nigeria, she boarded a plane and arrived in the United States of America. She wasn't a black woman back in Nigeria, but suddenly she ended up being a black woman in the United States. And that's what context is. You are not black in Nigeria. You're just who you are. You're the person in Nigeria. Resonance to the United States. So it's important to think and translate intersectionality in your own context. Do the job. Think about your own colonial histories, your specific socioeconomic conditions which have sort of lasted through generations, and see where exactly does context come in? How do we translate intersectionality into our own vernaculars? But the last thing to press on about intersectionality is really that none of this is a project of changing something a little bit, or giving a little bit of cash assistance to black women, or some cash transfer, or give them some kind of affirmative action, and that's how we'll address intersectionality. The point of intersectionality, using the framework, the theory of intersectionality, which comes through us from black women, is really to say that we want to transform how the world looks like. We want to transform what social inequalities look like. And unless we dismantle, we reimagine discrimination and the way that it's organized, we will not fulfill our task of dealing with intersectionality. So those are the 5 things which I think make up intersectionality. I'm very happy to take questions to address any of them. I just want to take you through 5 quick myths about intersectionality to say what it's not about. Right. It's all black women. It's not all about black women. Intersectionality comes from the rich history of critical race theory, critical race feminism, black feminism in the United States. But it also comes from Dalit women and the theory and the practice they've developed in India, as I'm sure there are third world, global south feminisms all around the world which have contributed to intersectionality. It's only that the term intersectionality comes from the United States in Kimberly Crenshaw's piece, which was written 30 years ago, that we refer to that framework. It's an exceedingly helpful framework, but it tells us that it's the framework that matters and that we should continue to use that framework across different cultures. So think about intersectionality as relatable, whilst also using the black feminist context to help you understand what it really looks like. It's for everyone. This is a hard one. So it is for everyone in the sense that everybody who is intersectionally disadvantaged is a subject of that theory. But it's not really about everyone, except that as we say, oh, Black lives matter, everyone's lives matter. It's as much and equally for people who are advantaged as it for disadvantaged. I don't think people who are not disadvantaged were meant to be the protectorate, as we say, of this theory. This is not really to say that everyone matters, that intersectionality is universal and that's how life is organized. It's really a subversive theory of disadvantage. I think keep in mind the talisman which Gandhi gave us, that if you're thinking about organizing your actions or ways of being, you're thinking about the person who is the most disadvantaged. That's what intersectionality helps you imagine. who is the most disadvantaged person. And often the most disadvantaged people are going to be those who are going to be multiply disadvantaged. So it is a theory of disadvantage. It's not just for everyone. It's passe. So this is the big critique. Everybody thinks, oh, intersectionality, yeah, we all know what it's all about. It's a very hard thing to understand. It's very hard to translate it. It's the time for intersectionality is gone. I think we're too quick. The simple response to this is we haven't quite managed to get to grips with the deep-seated intersectional disadvantage people are facing. So look at COVID-19, the way inequality has exacerbated, right? So we're thinking about migrant workers, women with children, people who have very little food stocks to go from one week to another without employment, left without any cash transfer. Add on top of it, people who are disabled, people who need assistance, who need care work at this point. Add to it disadvantage based on race and ethnicity, people who have been at the margins of the society. Too bad if you're a woman and disabled at the same time. If we haven't yet reached those people through law, through human rights law, through discrimination law, then intersectionality can't be passe yet. Right? So our work is not done yet. So critiques should be sort of approached from a point where it helps see intersectionality in an improved light rather than seeing like, oh, we've understood everything. If we had, we would have gotten it right at this point. It's all about discrimination law. No, it's not. And here's is a cheap plug to why it's not all about discrimination law. Some of us have been working on an edited volume, which is called Intersectionality and Human Rights Law, thinking about how the theory of intersectionality speaks to the broader comparative and international human rights law perspective. It's relevant to the whole field of law, I would imagine. So if you're doing tort on contract, for anybody doing that, think about how it relates to your discipline. I think we'd have to do our own research in terms of translating intersectionality across all of the legal spectrum. Finally, it is everything. Intersectionality is going to give you all answers and it's going to solve all problems. I'm afraid it will not. So I think intersectionality, especially when used as the bait of constantly prodding people, is like, oh, you didn't get it right. Intersectionality exists here and it's about everything and you possibly can't get it right without doing intersectionality. I think a lot of it is good insistence and good practice to remember intersectionality. But I don't think it's one-stop solution to all problems of global inequality and justice. So I think we should stop approaching intersectionality as this panacea which is being handed over to lawyers to suddenly make law more subversive and have all answers. It is something. It's a useful tool. Use it far as it gets, but don't use it as a solution or as a weapon for all things. It, for example, cannot offer a vaccine for the pandemic, but it can help you understand how inequalities have been exacerbated in the last few months because of the inequalities which have always existed. So that's all for me. I'm very excited.
Okay, thank you so much, Shreya. That was a really engaging and fun overview of the book. So thank you for that. Let me just say a couple of things before we move on to the commentary. The first, which I should have said at the beginning, this is a terrific book. And you all owe it to buy yourselves a copy. It's wide-ranging, it's fascinating, it'll make you rethink discrimination law and everything you thought you knew about discrimination law. The second thing is, if any of you have questions, please feel free to send them to me via the chat feature. And then in the last half hour of the seminar, I will ask as many of those questions to Professor Atrey as I can. Okay, so please send me your questions if and when they occur to you. With that said, let's turn over to the commentators. First, my colleague, Professor Mara Malagodi.
Thank you so much, Rehan, for the introduction. Thank you so much, Shreya, for being with us. I have to say, I'm terribly sad not to have you here in person. But given the circumstances, I'm glad we could still go ahead with this. It's a privilege for me to respond to your excellent book, Intersectional Discrimination. I just wanted to say at the outset that my response today to the book is from the perspective of a comparative constitutional law scholar rather than a discrimination lawyer. So that's the focus of my thoughts and response. In particular, one of the questions that I had in mind reading the book and engaging with it was the focus on the way in which the constitutional right to equality, which underpins in a lot of the jurisdictions that you talk about, relate to the concept of intersectionality and what lessons we can learn. In particular, what I would like to do today, very briefly, is to probe the way in which this relationship sheds light on questions concerning constitutional identity and the role of the constitutional sphere, especially adjudication. I think you make that point quite forcefully. I'm going to press you on that a bit more, in molding a sense of national belonging and somehow in unhinging or even reproducing internal social hierarchies. So I'm going to start with the problem that you engage with in your book, and the fact that you grapple in particular with one puzzle. Why the concept of intersectionality has not gained traction in the field of discrimination law, where it actually originated, as you said, in the late 1980s. And also, so it's not just a theoretical question that you posed, why it doesn't really, in terms of a disciplinary question, why not discrimination law, which is kind of ground zero for the concept, but also in the actual adjudication of discrimination cases. So you talk about the fact that a lot of the explanation is that, well, discrimination law across the jurisdictions that you've considered and studied remains largely single axis. And then, of course, when we talk about intersectionality, and that your very helpful PowerPoint and excellent definition of what the concept is, talks about this multiplicity of identities and the way to explain this advantage. I think that really relates to a lot of the questions that we need to address. So if we start from this failure that your book highlights and this paradox, so what does this failure of discrimination law in adopting a truly intersectional approach to equality disputes tell us about the relationship between constitutionalism, equality, and ultimately national identity? So to me, it's quite interesting to kind of take a macro view of the concerns that you investigate in the book and your conclusions and kind of relate them to a big picture set of questions. And I guess also you talk about context, and I think those questions are very important, and your contribution to this field is absolutely tremendous in general, but also more specifically in the kind of political climate in which we are today, in the kind of political space that we inhabit. And I'm thinking about a phenomenon that we see around the globe, a massive surge in ethno-nationalism, greater challenges to constitutional democracy everywhere, more forceful attacks on the courts across the globe, and finally, what we see, especially, well, I think not especially, again, generally, a backlash against what is being called identity politics. And to me, what's really interesting is that your intellectual project really helped me to advance my understanding of the role of law in addressing structural equality. And in a way, like, to what extent does the law help or not in this search for greater equality and a more substantive equality that is able to take into account the variety of disadvantage? So I'm going to start by engaging with the argument that your book puts forward and kind of frame that in the context of comparative constitutional law and my understanding of your framework. So you talk about the fact that I think it's really important that there is no single maneuver that can single-handedly make discrimination law respond to intersectionality. And you talk about this beautiful image, this beautiful metaphor of discrimination law as a giant wheel. And you look at the different components of all of that. From a comparative constitutional law perspective, what strikes me, and we were discussing that earlier on with Rehan as well, is that the underlying claim that I see in the book is that courts matters, and they matters enormously. Not just in terms of the outcome of litigation, but also in the expressive power of litigation. So if in your response you could say a bit more about this expressive role of litigation, its expressive power, I think that would be very, very helpful, because I was curious, I grabbed that reference throughout the book, and especially in the conclusion, and I thought that was really important. You also go further and talk about the fact that in discrimination law, it is not so much about the drafting of the text, so not so much about the statutory basis of discrimination law or the actual text of the relevant constitutional provisions, but it is very much about interpretation, and I take that to be judicial interpretations that judges offer of the grounds and the broader mechanisms that support the apparatus of discrimination law. So it's very much, interpretation is both, it seems to me, the lever to make discrimination law more intersectional, and at the same time, it's also the obstacle that you identify in your analysis. So to me, that really links with the goal of your project, which is not just theoretical, it's very pragmatic. And it's this idea, and it's ambitious, it's pragmatic and ambitious. And it is to effect changes in the judicial disposition and language used by the judges when deciding on discrimination cases, so that courts, as both national and international levels, can truly deploy an intersectional approach. So I have a question here. So is that a question of the scope and breadth of interpretation? So are we talking about a more expansive and more liberal interpretations that courts should render, specifically with regard to grounds of discrimination? And is it just a question of statutory interpretation in this kind of disputes, or constitutional interpretation of the relevant provisions? And if judges were to do so, do you think we would see a further backlash against what's often being described as judicial activism, or not? Is that a potential fallout of what I read as one of the perhaps recommendations that the book may want to make? And then I wanted to move on and look at the case selection and the jurisdictions, particularly the national jurisdictions that you engage with in the book. So you look at particularly cases from the US, the UK, Canada, South Africa, and India. And you also look at the decisions from different UN treaty bodies. But I wanted to push you a little further on the national jurisdictions and the reasons that you selected those jurisdictions, even if I can infer, and if there are also practical reasons, I would think. But at the same time, looking at the fact that we're looking at, in the case of the US and the UK, very well established constitutional democracies, which have had their problems recently, but we're looking at that kind of constitutional setup. We're looking at South Africa, which is it's been at the center of a very prolific area of constitutional legal inquiry, which is transformative constitutionalism. So the idea is that we're looking mostly at constitutional democracy, and yet we go back, and that kind of introduces the conclusions that and the last few questions that I have for you. You talk about this paradox of discrimination law, and we're talking about the fact that the worst forms of inequality and disadvantage have not been properly addressed in the field of discrimination law. So if I link this paradox to your case selection, and I'm looking at advanced constitutional democracy, I'm looking at the case of South Africa, which has a thriving area of equality jurisprudence, what kind of conclusions do we draw here? And we're talking about a failure, especially on the part of the courts, to adopt a truly intersectional approach, even if we have a few cases where judges have been more sensitive and more attuned to the prescriptions of intersectionality. So I was wondering, what can we gauge from bringing together the case selection, questions of constitutional democracy, and the centrality of the notion of equality to mature constitutional democracies, and questions of how do we advance the two in that kind of context. So those are kind of very broad points, and I would like to stop here because I'm quite interested in your response here, what Kelley has to say, and I just want to say that I've enjoyed the book enormously, and it's a terrific contribution. And thank you.
Thanks very much, Mara. I guess we'll move on. So I invite Professor Kelley Loper to give her comments.
Okay. Hi, everybody. First of all, I want to thank Rehan and Mara for the opportunity for inviting me to participate in this fantastic discussion, and also especially to thank Shreya for writing her book, and therefore giving me the chance to read her book, which is absolutely amazing. It's excellent, comprehensive, clear, convincing account of intersectionality. And I should just say I loved it. And I'm already consulting it frequently in my own research and teaching activities. In particular, as a teacher, the book has really made me question and has challenged me to re-examine the entire structure of my elective course on comparative equality and non-discrimination law, which I've just finished teaching for this semester, so I'll have to restructure it next year. But for years, I've organized the course topics according to a limited number of particular atomized single-axis grounds of discrimination. So it starts with race, ethnicity, moving on to sex and gender, disability, etc. And then in the very last session of the semester, we finally talk about intersectionality. And I hate to confess that, to be honest, it's often been something of an afterthought. At that point, I joke with my students that I probably need to reconsider the organization of the course. And now, after reading your book, Shreya, I realize that, yes, I absolutely do need to reorganize the course. So I decided what I should be doing is starting as well as ending the semester with intersectionality, and also getting the students to apply intersectionality throughout as at least one framework. And I know it's not the be-all, end-all, even for discrimination law, as you pointed out, but at least one of the frameworks for our analysis of these protected characteristics and other elements of discrimination law. And as the book makes clear, intersectionality can help us evaluate judicial decisions, identify what aspects of discrimination that the courts get right and what they don't. And this is certainly a helpful exercise for teaching as well as research purposes at the very least. I've also gained a much better understanding by reading the book of the connections that exist between intersectionality and discrimination law. And as you explain in the book, and I quote, intersectionality shares the reflexive middle ground with discrimination law of working with and being critical of identity categories. So my reading of this is that discrimination law, excuse me, and a grounds-based approach are not per se antithetical to intersectionality. And in fact, a proper application of intersectionality could help discrimination law get back to its origins and function in the way that it's meant to function and achieve what it is supposed to achieve. Excuse me. In other words, discrimination law might finally be able to become its true self in a certain sense. So in this way, intersectionality might actually be viewed and understood as something of a conservative project. So in fact, as I read the book, it was this middle ground that I kept coming back to, and that really struck me most. And the dynamic between the potential of intersectionality to transform, as well as to provide a pragmatic response to addressing real disadvantage. So it's not an appeal to completely jettison discrimination law altogether and start again. However, often we may want to throw up our hands in despair at all of the limitations of discrimination law and its inability, at least in most cases, to support substantive equality. Instead, intersectionality asks us to recalibrate, as you put it, Shreya, the existing components of discrimination law, rather than to completely dismantle them, and to see how these elements work together. And I also found, like Mara, the book's image quite striking of interrelated cogs in this complex, holistic wheel. Courts, in many cases, should be able to interpret current laws in ways that recognize, accept, and apply intersectionality. And it seems to me to be a bit about preserving certain elements of discrimination law, maybe with a bit of tweaking, and in ways that ensure discrimination law is able to realize its original transformative aims. So this, to me, is one of the most important insights of the book. The intersectionality, while theoretically rich, can also serve as a very practical guide. Despite the fact that intersectionality may be somewhat less revolutionary than some might assume, the resistance to intersectionality, as you noted and as Mara noted, is still notable. And I'm curious about the factors that might have contributed to that resistance. And I'd also be interested to hear your views about this. As we see in the very impressive array of cases that you've expertly considered in the book, the courts only get it right a couple of times, seem to have only got it right in a couple of times, even in these more advanced constitutional democracies. So how might we account for this? And why the unfavorable judicial attitudes? This is linked, I think, to Mara's question as well. Is it merely due to a lack of awareness on the part of judges and lawyers? I mean, maybe most equality law courses like mine in law schools don't sufficiently or correctly include intersectionality in the syllabus. Is it the lack of diversity on the bench? Might there be a more cynical explanation? Are courts deliberately trying to limit the transformative potential of intersectionality? This possibility reminded me of a pointed critique of the Australian High Court by Sidursky in an article he wrote back in 1986, where he notes the court's overly formal application of discrimination law when deciding that certain aspects of land rights granted to indigenous communities were discriminatory on the grounds of race, but then that they were saved by an exception for special measures. And he calls it, I think it's the title of the article, the landmark case that wasn't, and surmises that the court made the right decision for the wrong reasons, but then goes further and writes that this was, quote, not by accident, not by mistake, not by a conceptual error, not for the lack of intellectual capacity, but that the court, as a representative and enforcer of the dominant values of the community, had to make sure that the sweep of its potentially important decision would be strictly limited, that the decision would not be read as a threat to the patterns of social privileges, and that it would not generate any demands for broader social reform, end quote. So I wonder, could something similar be going on when courts deal with intersectional claims? And I would be curious to hear your views about that. I would also suggest that resistance could stem from the piecemeal approach to discrimination law in many jurisdictions, which have gradually introduced statutes one by one, focusing on single grounds. And does the message of fragmentation produced by this process tend to reinforce the problem in various ways? So, for example, the fragmentation in the law might inadvertently undermine advocacy by identity-oriented civil society groups. I've seen some organizations in Hong Kong succumb to the single access message and mentality and are not always willing to form what could be productive alliances with other groups or recognize commonalities, including their shared disadvantage. And they sometimes appear to be stuck in the box of a particular single identity. So the sites of resistance to intersectionality are not limited to the courts. And political resistance has also been notable in Hong Kong for decades in this field. So back in 1994, the Hong Kong colonial government opposed a progressive, comprehensive equal opportunities bill that would have covered a broad range of grounds and might have paved the way for greater attention to intersectionality in this context. The government countered instead by first introducing a law prohibiting discrimination on the grounds of sex, followed a bit later by disability, then family status, and then more than a decade later by race. And now they seem to have stopped altogether. So my question is, how do we proceed from here? And how do we take the insights of your book and use them to better advocate to redress intersectional discrimination? How do we ensure that intersectionality is properly applied by courts, lawyers, politicians, civil society organizations, and others? And in that way, produce transformative outcomes. Just one more thing before I finish. I want to mention a space that I think is worth watching, but I'm not sure, I don't believe was discussed explicitly in the book. And that's the jurisprudence now being produced by the UN Committee on Economic, Social, and Cultural Rights, which is the international treaty body tasked with monitoring states' implementation of their obligations under the Covenant on Economic, Social, and Cultural Rights. That context might be especially helpful to highlight the effects of poverty, socioeconomic status, in conjunction with other grounds or types of disadvantage. One recent case in particular suggests the committee may be taking intersectionality seriously. This was decided in 2018 and involved a claim against Ecuador based on the rights to Social Security and non-discrimination. The Ecuadorian government had denied Social Security payments to the claimant, who was a woman who had been an unpaid domestic worker, taking care of her home and children, but had contributed anyway to a voluntary Social Security scheme. And in deciding that Ecuador had violated these rights, the committee observed that the claimant is, and I quote, an older person who is in a critical economic situation and has health problems, and that the intersection of the alleged gender and age discrimination makes her particularly vulnerable to discrimination in comparison with the general population. So I'd be curious to ask you what you think the potential of the Committee on Economic, Social, and Cultural Rights jurisprudence might be in this area. I think that's all I was going to say. On that note, I'll stop there. And once again, many thanks to Rehan and Mara, and a profound thank you to Shreya again for writing such an excellent book. Thank you.
Thank you so much, Kelley. That was terrific. Actually, thank you both. Those were really stimulating comments. Both posed a lot of questions to Shreya. So perhaps, Shreya, you can take a couple of minutes to respond to any of those or all of those as you see fit. And then hopefully we'll still have a little bit of time for questions from the audience.
Fantastic. Thank you, Rehan. I can't thank Mara and Kelley enough for being dream readers for the book from both of your perspective, from Mara's comparative constitutional perspective, and Kelley's very embedded equality and discrimination law practice. Frankly, I couldn't have wished for more sort of involved readers who sort of read with a sense of being with the project, and being as reflective as we both are. So thank you both, really. There's just so much to talk about, and those were the good days when we could just keep on chatting after the seminars and wander off to a pub, especially in the UK context, or similarly in Hong Kong somewhere. And that's where magic of academia happened. We don't have that opportunity today, but we have our incredible audience and the listeners are there. So I'm not going to try to respond to everything. There's just no way. I'm going to pick up on some of the things which have really bothered me as much as they have Kelley and Mara, and say something about them. Mara, your question on the role of law, especially courts, in going knocking at their toes to be expecting social justice and substantive equality issues to be solved. I mean, this is really something which bothered me as much as it bothers both you and Rehan both so deeply in constitutional adjudication context, to know that asking much of courts is basically how far do we get? Not very. And this was a real danger to me. And I don't think I take away anything from the project in being honest about this. That to me, the hardest thing was to strip intersectionality from its subversive and radical nature and transpose it into a context and constitutional adjudication, uh, and really expect that it'll be addressed as intersectionality. Because when you come close to the kind of power judges wield, you transformed in the process. You don't transform these structures, right? So the biggest danger in writing this book was really, are we expecting too much of the quotes? And I think the answer really was given to me by all of the insistence on Black feminist literature in not leaving or not ceding ground in constitutional adjudication to anything else. They're like, if this is the little ground Constitution allows us, we will take it and we will do whatever we can with it. And I think it comes from a deep sense of awareness of just how compromised communities are, for whom, when they begin from ground zero in these battles, so I don't think intersectionality has been addressed anywhere well. If you're beginning from that ground, you're not hedging your bets, you're not strategizing, you have nothing to lose. And I think to try to look at courts and the role of law in this case as, you know what, we have nothing to lose here, law better try to get something right in this context, was just the only purpose. And I really hope in that process we don't sort of strip intersectionality of its subversive potential. I'll try to say something about Kelley's point. But why don't judges just get it? And I've not said anything at all in the book about what could potentially be the reason for why we just don't seem to get intersectionality right. And you're so right to say, is it because of the diversity of judges? Old, white, male, middle class, non-disabled men are not going to just get it. That's one possibility. Or we can be cynical that they get it, but they have the most to lose in bringing intersectionality from margin to center, in Bell Hooks' words. When you hold power, you know so well what losing power looks like. Better than those who are trying to wield power, better than those who are trying to subvert structures of power. So it's not the Black women who know exactly what they're arguing for in these things, but it's the judges who know very well what it could mean for them. It could be that. It's also that maybe that they're lazy, or a practical concern of the very nice quotes that you had, Kelley, there, that this is possibly just knowing your own institutional limitations and being very clear about what you can achieve as judges. And as Mara said, we should be aware of the backlash against judicial activism, as all of us who work in this area know that activism from judges is a good thing overall, but extremely hard to get right. And given all those limitations, judges are right to be cautious in taking all this. I think all of those may play into why they don't seem to get it right. But in terms of answering your question, Kelley, how do we judicially, politically, socially mainstream intersectionality? I am reminded by this adage who one of my mentors and teachers has left me with permanently. When I read disability law with Professor Amita Dhanda, who's an Indian professor based at Nalsar, she always says, as a disability lawyer, never stop to ask the disability question. And I think the mainstream intersectionality is to never stop to ask the intersectional question. it's no matter which context we come from in law, even if you're working not on human rights law, if you're working on commercial law, you must still ask the question of what intersectional, just what intersectional dimensions you're thinking about in terms of your workspace, in terms of what you're thinking about as the value for your project, in terms of who is it contributing to, in terms of what is it all geared towards. I don't think anything is insulated from that question, and trying to answer that question at each point is the only way to actually do it. One of the big intersectional theorist is Toni Kadeh-Bambara, and she was asked about how to get intersectionality right, and she just looked like, well, what do you mean? How do we do intersectionality? We do it by doing it, and part of it is just that we're not doing it, and I think if we transform ourselves into intersectional lawyers, we'll be able to do it. We have been able to do that with other things. I think we're all trying to think in terms of sustainability and climate change, but somehow we are unable to do that in the equality realm. And this really troubles me. If you ask the person on the street, what do equality lawyers work on? They'll be like, oh yeah, you guys work on poverty. None of us do. And that's just so troubling. That as discrimination, as equality lawyers, we have bothered with everything but for the inequalities which are the most deep-seated inequalities. And the only way to get them front and center is just by getting them front and center, and by insisting on everyone around us to do it. Rehan, can I hand over to you?
Sorry?
Can I hand over to you? Is there any questions?
Yes, sure. So there have been a few questions. Maybe I'll ask you a couple, and you can answer them together. So the first question, the participant wants to know more about the transforming part of your definition of intersectionality, and they ask, is the transformation necessarily good or bad? And is it defined in terms of power or access to advantages?
Yeah, that's an excellent question. And I think that's really the X factor, so to say, of intersectionality. It's so, as you know, in philosophy, we would say the moral point and purpose of intersectionality is transformation. So I'm glad you asked. It has to be good. We as intersectional scholars cannot hope for anything other than utopias, just imageries of world which looks different. We're thinking of just taking apart that structure which intersectionality reveals and making something else. Here's the structure of intersectionality, and that's what we're transforming. So, when you start Kimberly Crenshaw's article, the 1988 piece, she has an amazing structure, the basement structure. And she's imagining inequalities in the world to be organized as a basement where people who are intersectionally disadvantaged at the bottom. And at the top are those who are disadvantaged by nothing, right? So you're thinking in terms of white, middle class, non-disabled, heterosexual men at the top who are not disadvantaged. Below them are people who are disadvantaged by one thing, right? So because they are women, so just by their sex or gender, but they're not disadvantaged by their race. And everyone who's disadvantaged by a single thing are below them. And the entire structure of the basement is such that everybody who is disadvantaged for more than one thing stands head on shoulders above those who are disadvantaged on more than their disadvantage. So you basically carry the weight of those who are disadvantaged less than you on top of you. And that's how the pyramid is organized. That's the basement imagery Kimberly Crenshaw brings up. We have to somehow make sure that that entire basement imagery doesn't exist. We jumble it up in such a way that that structure dismantles. That's the transformation we're imagining. Right. But I think one of the things to think about in this context is what Kelley said. We're not looking for transformation in the sense of overhauling the good structures which would help transform this inequality. We're not looking for dismantling discrimination law. We're looking for using discrimination law in a way to transform this basement or this structure. So I don't think we need to, here in this context, think of the classic black feminist phrase, the master's tools will not dismantle the master's house. There are no other tools that we have, right? These are the tools, and we will do whatever we can with the constitutions that we have, with the human rights and imaginations that we have, to use them in such a way such that they can be truly transformative. I don't think this is a project which is exclusive to law. So transformation cannot happen unless social movements and their tools and ways of transforming are engaged with. I think these go together. I don't think law is, again, one solution to everything, but it's one of them. And transformation in this context is imagining those utopias there could be whilst using the tools that we have, while also giving space to other tools other people are using, including social movements. So all of the history of intersectionality is rich with how social movements have used intersectionality, right? The classic example for everyone is Me Too. So hashtag Me Too was started by Tarana Burke, who was working with young girls, black women who were sexually harassed and sexually exploited and in very, very dire conditions of having faced sexual violence. And that's the origin of Me Too. And that's the story of how social movements use Me Too before it became the hashtag that we all use in 2018. So I think for us to try to plug into what's happening in terms of intersectional social movements around is just one way to say, look, transformation is a shared project. Let's not treat it as, lawyers are going to now come and just have a magic wand and do this right. I think we'll have to share space and really bring together people who do this on the ground. Only then can we imagine the transformative utopia that we're imagining. But in terms of access to advantage or dismantling power structures, I think that's a harder question to answer. I'll just refer you to, actually, I've been working on this. This is a tough question because I just want to say for those of you who are not as well versed with the nitty-gritty of discrimination law, frankly, it's as I find it as boring as you would. But just to say that discrimination law is a limited site. Access to advantages is not exactly what it allows. That's a normative claim I'm making. I can't defend it, I'm afraid. But I'm just saying discrimination law as a project is limited to equal opportunities more than access to advantages. So try to think of this as in terms of affirmative action. Affirmative action is not really giving you access to advantages, which is it's a sad framing for it, because I think all the claims by the Asian parents who are suing Harvard, saying like, oh, my kids who've done so well cannot get into Harvard, or all the claims of white men who say, look, affirmative action is giving advantages to people. It's not really. It's just dismantling the disadvantages that there are. It's a very limited project. Affirmative action does very, very little to actually get people to the right starting point, to actually have them run the same ways. So I don't think we're going to achieve a grand scheme here in terms of transforming just through discrimination law. But what it would do is just have a black woman have a day in court. And that's a pretty big deal in the current state of affairs. So I just want to think of transformation in terms of where we are at. And if we are at a point where, say, a disabled Muslim gay man or a disabled black woman has no access to claiming discrimination, then just by allowing them access and having them have their day in court, we would have won something in law or just in pure like legal terms. Thank you for that question. Really excellent question.
So our colleague from the history department, Stuart McManus, has asked 3 questions, but perhaps I'll ask one in the interest of fairness. And that is, what is the evidence for the synergy between different types of discrimination beyond the unity of individual subjective human experience that would justify an approach that goes beyond treating race, gender, ability, etc. separately.
Right. That's a very good point, Stuart. On evidence, so this is the big part of intersectionality scholarship, which we don't do ourselves as lawyers. We rely on social evidence which has been gathered by sociologists, anthropologists, economists, political theorists, and political scientists. And that's where intersectionality has proliferated. It has a prolific existence in terms of what it is, because they gather the evidence with respect to what do multiple disadvantages look like. Take, for example, simple work which is done in the US with respect to access to education and employment. So in terms of Black women's wages, they earn less per dollar than white men, white women, and Black men, right? So they earn the least per dollar amount, which is about 56 cents per one white male dollar. And the interesting part about this research is that that even when Black women have the sociocultural capital that we say, which comes with going to top universities and working as lawyers or bankers, even in those sectors, that statistic remains in the sense that they still manage to earn less. So this is just capturing the socioeconomic disadvantage, which is so deep-seated in terms of just recreating patterns of disadvantage that it's impossible to escape that pattern. Even when you're so well-educated, you go to the Harvards, you go to top B schools, and you still in law firms and in top banks earn less. So that's the kind of evidence we as lawyers rely on to say intersectionality exists. There's evidence for that, and it should be redressed. The hard part, I think, is that not everybody is collecting this data. A lot of this is not government data. It's not state procured. This is all independent researchers doing the good job that they do with the small grants that they get. In the European Union, collecting data is not possible, especially data which is stratified in terms of telling us that this is not just data with respect to all women, but just breaking it down with respect to disability, age, sexual orientation. You can't ask that question. You can't do that kind of work for the European Union specifically, right? That makes it extremely hard. In the case of the UK, we have Equality Act 2010, which has a specific section on combination discrimination, section 14, where you can bring a claim on more than one ground, so two grounds. That provision was never brought into force. What it means is that all the provisions with respect to gathering data with respect to inequalities are not applicable in the intersectional context. So the data in the UK can basically miss everything about what is called the BAME category here. So Black, Asian, minority, ethnic, right? So if you happen to be a BAME woman, chances are no one's collecting that data. So other than the independent organizations, researchers who are doing this work, governments and states are not really collecting this data. And it's I cannot stress enough just how much we need just concerted effort at an institutional level to just tell us what intersectionality looks like on the ground, and it can only be achieved if we believe that it exists to actually find out. As researchers, all we can do is ask that question, look for it, and I think states are not yet doing that, and then that's the biggest hurdle we face with respect to statistics and data on intersectional discrimination.
Great. Our next question comes from a student who says, "Dear Professor Atrey, thank you so much for this fantastic seminar. As a year one JD student, I wanted to know your views about religion as a factor of intersectionality in the world in the current climate."
Yeah, for those of us who work on and in the European context, religion is a very, very hard one. Just grappling with the specific case of Muslim women, where religion seems to be amplified to an extent that somehow Muslim women are just Muslim, like they have no gendered sex reality, or somehow they're just women and they possibly can't be seen as being part of religion, has really made matters difficult to be finding an authentic advocacy at any level with respect to their headscarves, their dressing, with respect to their religious rights. The hardest thing about religion and intersectionality is that religion is an odd ground of discrimination. Right? When we think of religion, we're thinking about the freedom that comes with being a person of religion. Right? So you have an individual, a very personal freedom to be religious or not to be religious. And then you have the communal right to exercise that freedom with respect to others who are of that religion. It's a very hard ground of discrimination to protect in the sense that it doesn't quite sit well with the freedom, the liberty which comes with exercising it, because it involves fundamentally not dealing with it. You can only exercise certain kinds of freedoms when the state withdraws from just constantly poking at you to do something or not to do something. Religion insulates you in such a way that the state can't quite tell you in a lot of things what to do and what not to do. It's very hard to do that in discrimination context when you're asking state to constantly intervene, to say, oh, race is bad, right? So sociologists who work on race would say this is a construct in the sense that this is not a reality beyond that that's lived, that there is no inherent racial identity that we carry. It's hard to say that for religion, right? So it's a very hard thing for us to grapple in terms of intersectionality, where we want to address these head on, but we want to leave space for people to be autonomous human beings, to be religious in their context, right? So how do you solve the religion puzzle? It's a very, very hard one. PhDs are being written on it. As a first year JD student, if you want to consider writing a PhD, you're very welcome to contact many of us who are very interested in thinking about not just the position of Muslim women in Europe, but just generally how complex the idea of religion is in discrimination law as opposed to the broader human rights context.
Okay. If we have time for one more question, I'm going to let's do a very broad skeptical question that will allow you to sum up as well. And the question is, can the law really be an effective mechanism to addressing intersectional discrimination?
No, I'm totally on board with all the skepticism. Really, I think this is the easiest question to answer because, as I began saying, it's just a hard project because for so many of us who want more radical change, it's a complete downer to be working with law. We cannot achieve the kind of change we imagine in our heads with law. I will not sell a reality which will not come alive. I think we are dealing with very limited space here. I think this is the master's tool that we have, and they're extremely powerful in changing us in terms of believing in them. We start believing in the power of law, and we think, oh, how much it can do and change, and we read too much into the good judgments as well, as if they really change the position of the one black woman who might have had her day in court. It really doesn't change much. Why do we continue to do what we do in law, given the fact that I don't think we achieve as much? This is what we trained in, and I think we, as good black feminists have said, we will not cede ground, because if we leave, then you're ceding ground to exactly the kind of discrimination law which we find problematic. If you don't want to see more diverse benches, you can say that it doesn't matter. True, maybe it doesn't matter. But if we believe that this one site has to change with all others, then maybe it's worthwhile considering what we can do with the site. It's what we're trained in doing, and I think the familiarity of being lawyers, we know what game we are playing in terms of asking law to respond to radical ideas. At least we know our enemy, so to say. And I think we're fighting against law in the projects that so all of us, I think Kelley, Mara, Rehan, we don't. I don't think I can speak for all of you perhaps as friends. I don't think all of us just like believe that law is going to be the answer to our problems of social justice, or even beyond that, of the greatest problems that we face, climate change, sustainability. But at least within this site, you want to keep some of us here because we'll at least try to push far as we can. We know our possibilities may be limited, but I think if we continue to interact with those who are outside of the law and keep our heads sort of a bit low and our ears to the ground, I think we can achieve a lot in combination with other actors who don't use law, but have very similar ambitions in terms of changing and transforming the world.
Okay, with that, we thank you once again, Shreya, both for the wonderful book and this really, really engaging seminar. Thank you so much. Big thanks as well to Kelley and Mara for the terrific comments.
Thank you so much for inviting me to do this. I would have liked to be with you all in person, but it's so good to know that one way or another we are together, and we are deeply invested in thinking about the things that we're thinking. I really thank everyone who's been here from CUHK. Really appreciate it. Fantastic questions. Really appreciate it. I wish I could see you all, but one day, please write to me if anyone wants to reach out to talk about research. Kelley and Mara, you've been fantastic. I could not have dreamt for better readers. Thank you so much, and for all your work, which is so inspiring for me to have done my work. Thank you.
Thank you for those kind words, Shreya. Expect emails, I think, now that you've offered. And thank you all again.